Puck mic test. Puck mic test.
Good morning and welcome to the Wednesday, July 23rd, 2025 meeting of the Texas Commission on Environmental Quality. It is, what time is it, Mary? 9:37 a.m. I'm joined by my colleagues, Bobby Jeanette, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're ceq.texas.gov with your name, affiliation, and the item you'd like to comment on. As always, we will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking. And please check to make sure your line is unmuted before proceeding. Humorous, but a moment of gratitude to TCEQ staff. We had a lot of dealing with the catastrophic floods and the really tragic loss of life that we're still reeling from. My neighborhood has had several memorials, continue to have them. It is amazingly sad. But we had boots on the ground in Kerrville that did a tremendous job, and I just have such respect. But this is the team that actually worked in Kerrville: Amanda Butcher, Aaron Rodriguez, Neri Valdez, Joseph Garza, Anne Marie Revenberg, Alexander Saria, Rona Reza, Samuel Lopez, Danielle Hobson, Brian Will, Adrian Rodriguez, Paige Leal, Trent Marin, Devin Thomas, Jasmine Paradis, Frank Sanchez, George Ortiz, Joy Thurston Cook, Javier Aguiano, Sandra Gonzalez, Lori Wilson, Elijah Grandy, Chad Algren, Paul Rural, David Mann, and Richard Monrell. All of those staffers played a key role with rescue and recovery, and they will continue to do all the debris in the future, which will take months and months and months. Thank you to that team. You did a wonderful job, and the governor is really grateful as well. And I know the people of Kerrville and the state of Texas are grateful, and we are, as the commission, very proud of you. So with that, do you have any comments, Bobby or Katarina?
Well said, thank you.
Okay, let's call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning 130 Environmental Park LLC's limited scope amendment to municipal solid waste permit number 2383. The applicant should go first, followed by protestants, the ED, and then OPIC. The parties have been provided the following oral argument time limits: applicant 5 minutes, protestants collectively 5 minutes, ED 5 minutes, and OPIC 5 minutes. The applicant may save time for rebuttal as it bears burden of proof on the application. And with that, we'll begin with the applicant, and I believe we have Mr. Ryan here for them.
I'm Brent Ryan, attorney for the applicant 130 Environmental Park, or 130 EP. This case is governed by provisions in Senate Bill 709 and in your rules at 30562. They limit the scope of this hearing to the proposed permit changes and any additional matters about which the ED staff requests additional information. And they require parties opposing a permit amendment to present evidence that the draft permit prepared by the staff violates specifically applicable state or federal requirements. I'm going to talk briefly about what didn't happen in this case, and then about what actually did happen. First, the staff didn't request information about any substantive issue during their review. In particular, nothing about noise and nothing about odor. The protestants didn't present any evidence about the proposed changes to the permit. The ALJ didn't limit the scope of the hearing as required by Senate Bill 709 and 30562. And the protestants and the PFD didn't identify any specifically applicable requirement that the draft permit would violate. What did happen? Evidence was presented regarding the reasons for the proposed changes, including improved efficiency, reduced traffic volumes, and importantly, support for the permit amendment by Caldwell County and the Council of Governments. The ED staff and 130 EP presented evidence establishing the Senate Bill 709 prima facie demonstration. The draft permit meets all applicable requirements and will protect human health and safety, the environment, and physical property. 3 protestants presented lay witness anecdotal testimony about noise and odor they claim originated at the 130 EP landfill. Their testimony was not supported by any expert investigation or testimony, and not by any exhibits, data, notes, logs, calendars, or in any other way. Considerable evidence was presented regarding the facility's compliance history. In the 4.5 years this facility has been operating, it has earned a compliance history classification from this agency of high, the highest possible rating. During that 4.5 years, no complaints have been made to TCEQ regarding noise. Only 1 complaint has been made to TCEQ regarding odor. It was investigated by your staff and did not result in an enforcement action or even a notice of violation. During the daily rounds the landfill operations manager makes of the area outside the landfill property, he has never heard noise from the landfill or smelled odors from the landfill. There have been 4 or 5 odor complaints phoned into the facility. That's about 1 per year. 130 EP investigates all complaints, and odor was detected only once. Its source was a recently emptied trash container at a residence. Even though noise and odor are beyond the scope of this amendment, 130 EP took the protestants' allegations about those issues seriously and retained national experts to investigate. Based on their field investigations and evaluations of relevant data and other information, the odor expert testified that at locations closer to the landfill than protestants' properties, he smelled the landfill odor only once. But it was intermittent and so light that it was below the detection limits of standard odor measurement equipment. He testified he was not consistent with his field investigation and data evaluations, and that some of protestants' testimony was not only not credible, the conditions described were not even possible. He also testified, and I quote, "If odors associated with the landfill facility are ever detectable at the protestants' properties, they would tend to be low-intensity odors, infrequently detected, and/or detected for only limited periods of time. The noise expert's investigation and testimony showed that measured noise levels in the area around the landfill on weekdays, when the landfill is fully operational, are comparable to the ambient or background noise levels in that area on weekend days, when the landfill is not operating at all." Finally, in the Dyer case, the Supreme Court concluded that you have the authority to revise a PFD and the findings and conclusions in an ALJ's proposed order. You should do just that in this case and include in a final order the findings and conclusions submitted with 130 EP's exceptions.
Thank you, Mr. Ryan.
And we have Marissa Perales for the protestants.
Good morning.
Here we go. In law school, we were taught to analyze a legal problem using the IRAC method. That's issue, rule, application, and conclusion. And that method works particularly well in this case. The issue was already identified by the commission when the hearing requests were granted, and that is whether the applicant provided an adequate justification for expanding its hours beyond those in Rule 330.135. That's a disputed issue of fact, one that the commission determined was appropriate for a contested case hearing during which the parties could present factual evidence. The rule in IRAC is 330.135. That's the only substantive rule that applies here. It lays out the substantive requirements regarding operating hours which is essentially that waste can be accepted anytime between 7 and 7 on weekdays unless otherwise authorized. TCEQ's interpretation of the rule is part of the rule itself, and the preamble to Rule 330.135 specifies that operating hours that deviate from those in the rule must be considered on a case-by-case basis, considering the potential impacts on the surrounding community. To the extent there was any question about what the rule requires and the need to justify the extended operating hours and the need to consider the impacts on the surrounding neighbors, the commission, when it first considered the 130 EP's application for its initial permit, explained in its final order and in the PFD that the applicant bore the burden of proof to show that the waste facility operations outside of the default operating hours in the rule will not disturb the surrounding community. The commission explained that this was part of the rule. The commission explained that this was part of the applicant's burden if it sought extended operating hours. And following the hearing in that initial, regarding that initial permit application, the commission determined in that case that again, the applicant had not met its burden, and so it was issued a permit with default operating hours. It was not allowed to extend its operating hours. This should have made it apparent that extended operating hours are not authorized by right. That if it's referred to a hearing, the applicant must contend with evidence presented by the surrounding neighbors, including how they are impacted by the landfill's operations. You've heard an argument about, Senate Bill 709 and the fact that this is a limited scope amendment and how those rules should apply here, but those are procedural rules. The substantive rule that applies here has not changed. It remains absolutely the same as it was back when the initial permit application was considered. And the applicant still bears the burden of proof, even under Senate Bill 709. Sure, it benefits from a prima facie presumption, but the protestants get to rebut that presumption. And the commission offered guidance on what type of evidence would be relevant to do so. Now, returning to IRAC, the application. Application is where SOA comes in and where the ALJ's role comes in. The ALJ here evaluated the evidence presented, applied the relevant rules, and determined that the applicant had again failed to meet its burden of proof. To be clear, part of the reason that the ALJ came to this conclusion is because the applicant refused to engage with the evidence. The applicant presented some expert testimony, but when presented with the factual testimony of the surrounding neighbors who have lived everyday experience with the landfill operations, such as Miss Susan Lane, who experiences odors practically on a daily basis every time the landfill is in operation, the applicant refused to cross-examine her. So there was no back and forth, no engagement with her testimony on the part of the applicant. In fact, the applicant's closing arguments didn't even cite or quote to its own evidence. Had the applicant engaged with the evidence, had the applicant done what OPIC and what the protestants did, which was to cross-examine the witnesses and elicit testimony from all of the witnesses, then the applicant would have had to acknowledge that there was no justification for its expanded hours, that it presented no witness that had the authority to represent the 130 EP and that could explain the basis for the extended operating hours. It would have had to acknowledge that its odor experts' opinions were based on unreliable assumptions that were not grounded in reality.
That's time.
And I'll just conclude really quickly.
Go.
The applicant would have had to have reached the same conclusion that the ALJ reached, which is that it didn't satisfy its burden of proof. Thank you.
Thank you very much. Now we'll hear from the executive director.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel, and other parties. I'm Anthony Tatu. I'm a staff attorney with the Environmental Law Division, and I have with me Nikki Clark, who's with MSW Permits. We're both here this morning on behalf of the Executive Director. The Executive Director respectfully recommends that the Commission revise the proposal for decision and issue an order approving the permit application and the issuance of the draft permit. The applicant in this case submitted an application to expand their operating hours and waste acceptance hours at the 130 Environmental Park Municipal Solid Waste Landfill in Caldwell County, Texas, in accordance with 30 TAC 330.135. Those rules state that the waste acceptance hours for a municipal solid waste facility may be any time between the hours of 7 a.m. and 7 p.m. Monday through Friday, unless otherwise approved in the authorization for the facility. The current permit authorizes the operating hours, but the acceptance of waste between 7 a.m. to 7 p.m. and operating hours between 5 a.m. and 9 p.m. Monday through Friday. This limited scope amendment seeks to extend waste acceptance hours to be between 5 a.m. to 7 p.m. Monday through Friday, and also adding waste acceptance hours between 6 a.m. to 5 p.m. on Saturday, and operating hours between 6 a.m. to 6 p.m. on Saturday. The applicant provided justification for expanding their hours and stated that the expanded hours would allow for more efficient waste collection and disposal outside of typical working hours and peak traffic times. The additional Saturday hours will provide available weekend disposal for those individuals who may otherwise not have access to the landfill during the week. The TCEQ rules in section 80.7, which were promulgated following Senate Bill 709, state that the filing of the administrative record establishes a prima facie demonstration that the Executive Director's draft permit meets all state and federal legal and technical requirements, and if issued, consistent with the Executive Director's draft permit, would protect human health and safety, the environment, and physical property. The rules also state that the presumption established by the prima facie demonstration may be rebutted by a protesting party presenting evidence regarding the referred issue. The party may rebut the presumption by presenting evidence regarding the referred issue demonstrating that the draft permit violates a specifically applicable state or federal legal or technical requirement. In this case, there was no showing of a violation of a specifically applicable state or federal legal or technical requirement in the draft permit provisions at issue. The protestants have not rebutted the prima facie demonstration that the Executive Director's draft permit meets all state and federal technical and legal requirements as supported by the administrative record in combination with additional evidence provided by the applicant and the Executive Director. The draft permit, which was prepared by the Executive Director with the expanded hours, is protective of human health, safety, and the environment. We're available for any additional questions you may have. Thank you.
Thank you, Anthony. And now we will hear from OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta with the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and recommends that the Commission deny the draft permit. As we heard this morning, the only issue referred to the contested case hearing was whether applicant provided adequate justification to expand operating hours beyond those allowed in 30 TAC section 330.135. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that applicant did not meet its burden of proof on this issue. OPIC agrees with the ALJ's findings that the limitations on operating hours in Rule 330.135 were intended to protect surrounding communities from potential impacts from the landfill. As stated in OPIC's closing brief, a preponderance of the evidence shows that Nearby residents already experience frequent noise and odor from landfill operations. Extending hours would likely increase those impacts, and the justification offered does not outweigh the potential negative impacts to the community. For these reasons, OPIC supports the ALJ's conclusion that applicant failed to justify expanded hours and recommends that the Commission adopt the proposal for decision and deny the draft permit. Thank you, and I'm happy to answer any questions.
Thank you very much. Mr. Ryan, you have technically 20 seconds for your rebuttal, but we're going to give you 40 because I'm super nice today.
Thank you, Madam Chairman. Ms. Perales referred to the 2006 preamble to amendments to 330-135, the operating hours rule. That preamble, of course, did not create or establish any sort of permitting requirement. In addition, it was superseded in the 2008 rulemaking, amending 305.62 to provide for limited scope amendments to municipal solid waste permits, including revisions to operating hours. Thank you.
Thank you very much. Well, colleagues, after reviewing the record in this case, I don't believe that the ALJ properly analyzed this matter based on the statutory and regulatory requirements applicable to this limited scope amendment application. Quickly, I would note that there has been some discussion about a commissioner's remarks. Actually, my predecessor, Chairman Neerman, who I have very high regards for, during the agenda where the commission referred this matter to SOA and what they may have meant. But the commission's consideration must be focused on the statute and legal requirements for this application. As you know, to legally rebut the prima facie demonstration established by the filing of the administrative record, the protestants must satisfy two elements. First, present evidence that relates to an issue referred to SOA, and two, demonstrate that one or more provisions in the draft permit violate a specifically applicable state or federal requirement. Based on the record, I don't believe that the protestants satisfied either one of those two elements and therefore failed to legally rebut the prima facie demonstration. First, the protestants failed to present any evidence controverting the applicant's justification for extended hours that was included in the application. Instead, under the guise of facility hours, they raised issues regarding odor and noise, which are outside the scope of this limited amendment. Under the LSA amendment rules, the ED's review and any hearing on the application shall be limited only to the proposed changes in the permit. The only change requested in this application is to extend the facility hours. In landfill applications, odor issues are addressed through the facility's odor management plan, which is not being changed in this application and therefore is not a relevant issue that could be considered in the hearing under this limited scope amendment rule. And noise is not a relevant and material issue that the commission would consider in this matter because TCEQ does not have any noise regulations specifically applicable for landfills. In the PFD, the ALJ does not cite any legal authority that would allow her to expand the issues that could be considered under the limited scope amendment application rules. Rather, the ALJ incorrectly bases her recommendations to deny the application on language in the 2006 MSW rule preamble. However, the preamble does not establish rule requirements and was published before the limited scope amendment rules were adopted in 2008. The commission's discussion in the limited scope amendment preamble, in addition to the rule itself, make it clear that any hearing for a limited scope amendment application is limited to only portions of the permit and attachments to which changes are being proposed. So because the odor, nuisance prevention, and land use compatibility portions of the applicant's MSW permit were not requested to be changed in this limited scope amendment application, and the executive director did not request information regarding those matters during the review of the application, Evidence regarding those matters is outside the scope of this limited scope amendment and is not relevant to these proceedings. Since the protestants did not submit any evidence regarding the applicant's justification included in the application, I don't believe that the protestants presented evidence regarding the issue referred to SOA. Second, the protestants failed to demonstrate that one or more provisions in the draft permit violate a specifically applicable state or federal requirement. The administrative record provided the applicant's justification for the request for additional hours. In addition to the information provided in the application, the applicant's witness testimony and the Caldwell County Commissioner's Court resolution all admitted into evidence regarding the justification for the extended hours were uncontroverted by the evidence on the record. I don't agree with ALJ's interpretation that the 2006 MSW rule preamble creates a specific legal requirement that the applicant's justification for extended facility hours must be evaluated considering the impact on the surrounding community in a limited scope amendment application. Legally, the preamble cannot be read to create a new standard that is not in the rule itself. But also, I think it is clear that this preamble applies to the MSW permitting rules in place before the commission adopted the process for limited scope amendments, and therefore applies to broader permit amendments where the entire permit is opened for consideration and not limited scope amendments. When the commission created a process for limited scope amendments, the purpose was to provide for a much narrower review for several types of discrete amendments. Therefore, the ALJ applied an incorrect standard for evaluating facility hours in this matter and inappropriately based her conclusion on evidence that is outside the scope for the LSA application. Since I don't believe that the protestants legally rebutted the prima facie demonstration, I would not adopt the ALJ's proposed order as written. I will stop here to get my commissioner's thoughts. Commissioner Janeka?
Thank you, Chairwoman. Well presented, well laid out. I will acknowledge there were several elements at work here in this matter. I agree with you. Fundamentally, the protestants didn't appropriately focus on the justification, which I think is a little frustrating because they're, in my opinion, from my view of the record, probably could have been more in the justification and probably could have been more in the executive director's review and consideration of that justification make it into this matter in the record, but it didn't because the discussion largely stepped immediately off into what Chairman Neerman reminded all the participants heading off to SOA needed to be included only as rebuttal ancillary evidence of that initial primary discussion. So the other factors I just want to name are the statements or indications of local support and local endorsement of this action from the COG, from the local county, and also the disconnect where the clear evidence that surfaced at SOA and that the ALJ found very, very instructive and found the more compelling evidence presented, frankly, was the complaints, the experience of the community around this landfill that have not made it into our agency's complaint record, where we have a record of one incident, one complaint related to odor. I think that does present some disconnect, and that, in my opinion, increases the likelihood another court would find against a decision in line with the ALJ's decision here. So I'll stop there.
Thank you. Commissioner Gonzalez.
I didn't find that the ALJ aligned with the legal standard, and so I came to the same conclusion.
Thank you, Katarina. All right. There have been many changes to the proposed order that need to be made to implement the commission's decision. Instead of reading a lengthy motion to make the necessary changes, I'm going to ask Mary, the general counsel, and the chief clerk to distribute my proposed motion to you and the parties and to publish it on the webinar. I suggest that we take a 15-minute recess so that you can review the motion and we will discuss it when we get back. With that, TCEQ stands in recess. This meeting is back in session. The time is 10:24 a.m. Colleagues, do we have any thoughts on the motion? I know it was long, lengthy. Love to hear any thoughts.
I just noticed a couple of inconsistencies in it with regard to the capitalization of proposed order. So if the general counsel's office, I believe they can fix it under the clerical, but just so they know to
Yeah,
make those changes.
we'll absolutely find
Great,
those.
thank
and
you.
Fix them.
That is a good catch. Thank you. Bobby?
No comments.
All
All
right.
those years of law journal.
Well, before we vote on this motion, I want to stress that although the protestants' odor concerns are outside the scope of this limited scope amendment application, the protestants are not left without a regulatory mechanism to address their concerns. I would highly encourage that any of the residents in the area around the landfill to submit odor complaints to the TCEQ, our agency, so that the enforcement divisions can investigate and take the appropriate steps if the landfill is not adhering to the requirements in its permit. With that said, I move that we adopt the motion that I have circulated today from the dais.
I second the motion.
All those in favor say aye.
Aye.
Motion passes. Thank y'all very much. Give everyone a minute to move. All right, we'll go to item number 2.
Item number 2 is the consideration of the ALJ's proposal for decision and order regarding an enforcement action against Patrick K. Mora. Presentations will begin with the ED, followed by the respondent and the Office of Public Interest Counsel. The parties have been notified that they will each have 5 minutes of oral argument, and the ED may reserve time for rebuttal as the ED bears the burden of proof in this matter. And with that, we'll begin with the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Taylor Pack Ellis, and I'm a staff attorney with the Litigation Division, and I'm here today representing the Executive Director. I am here in support of the Administrative Law Judge's proposal for decision and proposed order as amended by the Executive Director's exception regarding the enforcement action against Patrick K. Mora. Respondent owns and operates a temporarily out-of-service underground storage tank system in Houston, Texas. There are 2 violations at issue in this case. First, respondent failed to demonstrate financial assurance coverage for damages caused by accidental release from the USTs. Second, respondent failed to update the UST registration within 30 days of a reportable occurrence, in this case when the USTs became empty. The ALJ found the Executive Director met its burden in proving each of these violations occurred. The Executive Director also showed that the proposed administrative penalty for this matter was calculated fairly and in accordance with TCEQ's penalty policy. The ALJ found that the Executive Director met its burden in this regard as well. The proposed penalty reflects reductions for respondents' good faith efforts to comply, which he completed after having received a notice of enforcement for the violations on November 30th, 2022. The Executive Director recognized that respondent submitted a UST registration form updating the agency of the status of the tanks on December 20th, 2022, and conducted a site check on January 20th, 2023 that removed the requirement for obtaining financial assurance. The proposed penalty also included a reduction for a respondent's high performer compliance history classification. The executive director submitted a minor exception to address a non-substantive change to the ALJ's proposed order, which the ALJ accepted. Respondents subsequently filed late exceptions, but the ALJ did not issue anything in response. Accordingly, we request that the commission adopt the ALJ's proposed order as amended by the executive director's exception. With that, I'd be happy to answer any questions you may have, and I'd like to reserve the remainder of my time for rebuttal if necessary.
Thank you, Taylor. Next, we'll hear from the respondent, Mr. Mora. Is he online? No?
He is virtual.
Give him a second. He's here.
My name is Patrick Mora. Can you hear me?
We can hear you. Thank you.
Okay, good morning.
Good morning.
Yeah, I received the proposal for decision on May 15, 2025. I'll start by saying that 90% of what Ms. Ellis stated against me is false. Number one, if you go to that page 16, she stated that the tanks, exact time the tanks was emptied was not established. I have email here dated March 19th. I sent to Ubaldo notifying him that the tank has been emptied on March 19th, 2020. On the 23rd of March 2020 at 9:47 a.m., Mr. Ubaldo responded saying, I have received and noted and documented. That is the letter right here I have in my hand. Mr. Ubaldo sent this to me, acknowledging that the tank has been recorded empty. I sent him exhibit, which I have here. I sent him, that's the receipt. Exhibit J is the receipt for the payment. Exhibit J3 is the picture I took of the tank, the company removing the waste, and the exhibit J2. Then on the case of not amending the UST, Mr. Ubaldo called me on the October 17th and told me, Mr. Mora, a mistake has been made, that the tank is empty, but TCEQ had it on file that is still full. So he said he will send me a document, which I received on October 20th. Turned out to be some citations and other pictures you want me to take and whatever. So I have in my hand here, which the court has, Exhibit H. I received this to fill out this amendment on the 20th of October. I filled it out on the 25th. If you look at Exhibit H, it says the date there is 25th, and I mailed it on the 27th. And according to Tiffany, it was received, I believe, November 1st. Now, here is the reason why this registration was delayed. I'm a very responsible man, even though I've been painted a monster. I called TCEQ several times. I spoke to Kimberly. On November 22nd, I asked Kimberly, I said, why is this taking so long? She told me that Tambra Rogers is in charge of processing the paperwork and she's on vacation. She told me, I asked her, can somebody else take care of this so I can forward it to Ubaldo TCEQ? She said, no. She said, nobody else can process this paperwork until she gets back. Her phone number is 512-239-6783. So I wrote to Mr. Ubaldo and I explained what happened to Mr. Ubaldo. I told him this is out of my control. I want to go on record to say that these violations are not mine and I have never operated a store, convenience store. These violations was Mohammed and the Wasi. But Mr. Ubaldo told me they can be found, which I knew they can be found. but I accepted responsibility and I corrected all the violations, dozens of them, of which 8 was in writing. Mr. Obado even acknowledged that I'm a very compliant guy. Now, if you go to the same page 13, she wrote failure to notify TCEQ of change or additional regarding the UST. I have turned in a record which shows 35 emails sent from me to Obado, notifying him of everything that I do, everything going on, additions, subtractions. 35 emails, documentations. That's a lot. I remember during the plenary hearing, the judge warned Ms. Park Ellis that there is a lot of documents. She said a lot of documents filed in Morrow's case. Now, Ms. Park Ellis still went ahead to deny, to accuse me falsely. Now, she said I operated a store. That store has been closed for 14 years. I've never operated it one day. What I did was register Top 10 Food Mart because I have intent of reopening it. I'm in search of loans. Okay.
I'll give you a minute to conclude.
Okay. She said that the document, the registration was received in December 20. That's a false. It was received in November. Tiffany Chu, during the trials, confirmed in front of the judge that she went to the portal, TCQ portal, and it showed December 1st as received. Her assistant attorney asked, was it in compliance? Tiffany answered, yes, that is in compliance. Now, in the case of the financial assurance, Mr. Obado initiated stage site check. I went all over contractors looking for somebody to do it. They told me they don't know what I'm talking about. Scott Stevens, the CEO of Environmental, after he has now enforced it, I had to search down the list again. Luckily to find Mr. Scott Stevens, who agreed to investigate, risking his license. He said, I'm do a thorough investigation before we do it. He testified in court that he has never heard stage site check. Ms. Park Ellis asked who initiated it. Mr. Gongoro testified in court that he is the one that initiated stage site check to me. And this is what caused the delay. Other than that, I will not be here today. I don't know what stage site check is. I'm not a professional. The professionals testified in court. They don't know what that is. So am I a very responsible man? I have done the best I could. I've spent thousands of dollars to bring the thing to court because I want to be in good book with TCQ because I'm looking forward to reopening the store. But I've never operated the store. What I operate in the property is my barber shop. I've never operated it one day. What I did was just register it money. And I find it hard to believe that the people that was responsible for this violation.
Thank
Thank you very much.
Thank you very much. I appreciate your comments. We will go to OPIC. Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. We participated in the evidentiary hearing on this matter and agree with the ALJ's disposition of the evidence. While OPIC recognizes the respondent's efforts to comply with the rules and remediate the violations at his property, these efforts do not obviate the fact that the remaining violations taken up at the hearing relating to failure to demonstrate financial assurance and submit a timely amended registration did in fact take place and warrant a penalty. Though we stated at the hearing that we would not object to further reductions in the penalty amount, we also recognize that the ED has already made significant adjustments to the initial base penalty amounts of $25,000 for each violation, including downward adjustments to the base penalty amounts for respondents' good faith efforts to comply and his compliance history. These considerations likely leave the remaining penalty amount of $5,000 as the most reduced form possible to maintain the integrity of the agency's enforcement system and outcomes. To conclude, OPIC respectfully recommends the Commission adopt its PFD and enter the proposed order.
Thanks, Garrett. Taylor, I believe you have 3 minutes and 42 seconds for your rebuttal, if you need it.
Thank you, Chairwoman. Commissioners, the rule requires to respondents' point that he provided facility information to the investigator. The rule requires that UST owners and operators register with the agency on authorized agency forms. Respondent was aware of this requirement and process as reflected by the record when he submitted a complete self-certification and registration form in 2021 to update the ownership of the USTs when Mr. Gongora first communicated with him. To his point about when the NOV was submitted, Ms. Tiffany Chu, EC, the TCEQ's enforcement coordinator and witness for the ED, testified that the registration form was signed and form was signed and submitted in October 2022 that was considered incomplete by the registrations team, and they communicated deficiencies to the respondent. And after that, he submitted a complete registration in December 2021 that was then, or sorry, December 2022 that was then processed. He also discussed confusion about a potential stage site check. Any confusion about the stage of the site check was on respondent's own making. Mr. Ubaldo Gongora, the investigator in this case and witness for the ED, testified that he informed respondent during a May 2021 investigation that in order to exempt the temporarily out of service USTs, he could perform a site check instead of getting financial assurance or remove the tanks. Respondent also received a notice of violation in June 2021, asking him to provide documentation that a site check had been conducted and that the tanks are empty or that financial assurance is provided. In September to October, he conducted the instant investigation to determine if those things had been concluded and determined that they weren't. There was still no documentation available to review. And in the exit interview for that investigation in October 2022, he also requested documentation of financial assurance or that a site check has been performed or any corrective actions have been completed, and which respondent did not complete until after the notice of enforcement in November 2022. Respondent's own evidence actually shows that as early as March 2020, Mr. Gongora had provided him the information on the site check and financial assurance responsibilities. To his point that any of the TCEQ staff testified in bad faith, the witnesses for the ED did not testify in bad faith or mislead the court in any way. Moreover, the evidence presented and entered into the record supports their testimony. Likewise, while serving as counsel for the ED, I did not testify or mislead the court at any time, including while presenting the executive director's case and questioning witnesses at the hearings. Additionally, if respondent had impeachment evidence, he could have brought that before the ALJ to rule on and have the witness questioned about them. So with the record, so that the record could be completely made, because he did not, we asked that he be stopped from attempting to do so for the first time here today.
Thank you, Taylor. All right. Colleagues, I've reviewed the record, the ALJ's PFD and the proposed order. The evidence supports the ALJ's conclusions and the proposed penalty. So I would adopt the ALJ's proposed order. We do have a quick housekeeping note on this one. The proposed order has former Chairman Neerman as the signatory, and he obviously will not be signing the order. He's quite the diva these days in these meetings. Rather than saying here who will sign the order, I'd ask General Counsel to use her delegated authority to make sure that the signature line reflects the commissioner who ultimately signs the order. Yes? All right, colleagues, any thoughts? Nope. Do I have a motion?
I move we adopt the administrative law judge's proposed order.
I second it.
All those in favor say aye.
Aye.
Aye. Thank you. Let's go to items 3 through 6, please.
We'll begin with item 3, and that is the consideration of an application by JC Water Resource Recovery LLC for new TPDS permit number WQ00163860001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, good morning, y'all. Before us for consideration is an application by JC Water Resource Recovery for a new TPDS permit to authorize a wastewater discharge of 108 gallons per day, 108,000 gallons per day in its final phase. We received a number of hearing requests on this matter and one request for reconsideration, raising concerns related to odors, facility operations, and possible impacts of the proposed facility on the requestors and their families' health and water quality. In my review of the hearing request and the responses, including the executive director's map depicting the discharge route, I believe that C.W. Howe, Curry Reagan, and Lyle Reagan are all affected persons in this matter. For those hearing requesters I did not find demonstrated effectiveness, I note that several of the hearing requesters failed to file timely comments during the comment period as required. And for several other requesters, the intervening distance between their residence in the facility and the discharge route make it unlikely that they will be impacted in a manner different than the general public, particularly in light of the relatively small size of the authorized discharge. So I would grant C.W. Howe, Curry Reagan, and Lyle Reagan hearing requests. Colleagues?
I'm in agreement.
Also in agreement.
I would refer 4 issues to SOA concerning nuisance odor, potential impacts to health, wildlife, water quality, including drinking water wells, and an issue relating to the operation and supervision of the facility. I would also deny the pending request for reconsideration and include a 180-day hearing duration and a concurrent referral to the Commission's ADR program. Bobby, Katarina,
I agree.
do I have a motion?
I move that we grant the hearing requests of C.W. Howell Jr., Curry Reagan, and Lyle Reagan, that we deny the remaining hearing requests and the request for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues, with a concurrent referral to the Commission's Alternative Dispute Resolution Program. Issue A, whether the draft permit is protective of human health and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue B, whether the draft permit is protective of water quality, including the protection of surface water and drinking water in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue C, whether the draft permit contains adequate provisions to address nuisance odors in accordance with applicable provisions in 30 Texas Administrative Code, Chapter 309. And issue D, whether the draft permit contains adequate provisions regarding operation and maintenance of the facility in accordance with applicable regulations under 30 Texas Administrative Code, Chapter 305. And that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
All those in favor say aye.
Aye.
Thank you. The motion passes. Go on to item 4.
Item number 4 is the consideration of an application by Tamco Building Products LLC for the renewal of air quality permit number 4421A. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. Before us, we have an application for a no increase renewal of an air permit. The commission received hearing requests and requests for reconsideration. For these type of applications, we must first determine whether there is a right to a hearing. Because this is a no increase renewal, and considering the applicant's satisfactory compliance history rating, I believe there is no right to a hearing in this matter. Under the Texas Health and Safety Code, Section 382.056, regarding the request for reconsideration, I don't find that they raise any new relevant or material information for the commission to consider. Therefore, I deny all hearing requests and request for reconsideration and issue the permit as recommended by the ED. Also reviewed the ED's response to comments and propose that we also adopt that document. Colleagues,
I find the same way.
I see it the same way.
do I have a motion?
I move that we find that there is no right to a hearing on this application pursuant to Texas Health and Safety Code, Section 382.056, that we deny all hearing requests and requests for reconsideration, that we issue the renewal of air quality permit number 4421A to Tamco Building Products LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
Do I have a second?
Second?
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. Let's go to item 5.
So item 5 was continued until the following agenda. So we'll move to 6.
Excellent.
Item 6 is the consideration. Well, I'll give everybody a chance to get up here. I'm just racing through it. Sorry. Okay, item 6 is the consideration of an application by the Dow Chemical Company for an amendment of new source review permit number 914 and issuance of an initial prevention of significant deterioration permit number PSDTX 1642. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning again. For this item, we're considering Dow Chemical Company's application for an amendment to NSR permit number 914 and an issuance of a PSD permit number PSD TX 1642. We had a single hearing request from the Southeast Texas Clean Air and Water Incorporated, or CAW. That hearing request failed to identify a member with standing in their own right to request a hearing. So I agree with the ED and OPIC that the hearing request failed to meet the requirements for granting a hearing. I'm also satisfied that CAW withdrew their request in their reply filing, so I'm prepared to issue the permit amendment and the permit. I've also reviewed the ED's response to comment and am prepared to adopt it as well. Colleagues?
I'm in agreement with you. I appreciate OPIC making the relevant motion here, but feel that moving forward as you propose, Chairwoman, today would be the most expeditious path forward.
Thank you.
I agree.
Do I have a motion?
I move that we find that CAW's hearing request was defective and that CAW's July 10th reply filing withdrew its request for hearing. That we issue the amendment of NSR permit number 914 and PSD permit number PSD TX 1642 to the Dow Chemical Company, and that we adopt the executive director's response to comments.
Second the motion.
All those in favor say aye.
Aye.
The motion passes. Thank y'all. We'll head to items 7 through 13.
Items 7 through 13 are the consideration of the withdrawal from EPA consideration of 7 SIP revisions, including the SIP revision for the Section 185 fee program rule provisions contained in 30 Texas Administrative Code, Section 101, 118A2 and B, the El Paso County Emissions Inventory SIP revision, and the 5 attainment demonstrations, RACM analyses, and motor vehicle emissions budgets included in the attainment demonstration SIP revisions for the DFW and HGB non-attainment areas to meet moderate and serious classification requirements for the 2008 8-hour ozone standard. The executive director's staff is here to present these items.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Allison Stokes with the Air Quality Division. With me today is Terry Salem with the Environmental Law Division, as well as Walker Williamson with the Air Quality Division, and John Mentor with the Environmental Law Division. Additional technical staff are available online. For your consideration today are items 7 through 13, the Executive Director's request to withdraw from the United States Environmental Protection Agency's review certain state implementation plan elements that are no longer required under the Federal Clean Air Act, and about which EPA has not taken final action. These include Section 185 fee rule provisions for the Houston, Galveston, Brazoria area for the revoked 1-hour ozone standard, the El Paso County emissions inventory SIP revision for the 2015 ozone standard, and portions of the moderate and serious classification SIP revision submittals for the Dallas-Fort Worth and Houston, Galveston, Brazoria areas for the 2008 ozone standard. Staff respectfully request adoption of these SIP revision withdrawals and are available to answer any questions.
Thank you, Allison. Any questions for ED staff? Do we have anyone signed on this item?
No one is addressed. No one is registered to address the commission on these items.
Thank you. OPIC?
Regarding item 7, Clean Air Act, Section 185 fee rules no longer apply to the Houston, Galveston, Brazoria ozone non-attainment area. OPIC understand A2 and B are withdrawn from EPA consideration. Then no EPA final action on them will be necessary. Therefore, OPIC supports withdrawal of these rule sections from EPA consideration as a SIP revision. Regarding item 8, in June 2023, the DC Circuit Court of Appeals reversed the non-attainment designation for El Paso County. OPIC understands that prior to the ruling, TCEQ had submitted for EPA consideration a SIP revision to satisfy emissions inventory reporting requirements. Because the SIP revision is no longer required and has not been approved by EPA, OPIC supports withdrawing it from EPA consideration. Regarding items 9 through 13, for the HGB and DFW ozone non-attainment areas, TCEQ made various SIP submittals between 2015 and 2020 related to attainment demonstration RACM or MVEB elements. Upon reclassification of the areas to severe, EPA stated that these specific moderate and serious elements are no longer Clean Air Act legal obligations and are not required SIP submittals. OPIC understands that because these SIP revision elements are now not required and have not been approved by EPA, the Commission may withdraw them from EPA consideration. At this time, we agree with and support the ED's recommendation to do so.
All right, thank you, Garrett. First, I'd like to thank staff on the work they put into these SIP revision withdrawals. As laid out by the ED today and in the backup materials, these SIP revisions are either no longer necessary or applicable, are no longer required, or are no longer considered legal obligations due to reclassification. Therefore, I would recommend that the Commission withdraw these 7 SIP revisions from EPA review as recommended by the Executive Director. Colleagues?
I agree, well said, OPIC, on laying out the reasons behind each of the different 3 sets of these actions.
I'm in agreement. And I know this has been a lot of work over the years with all the back and forth on the SIPs. I really appreciate this.
Yes, and Terry is the one who's the SIP whisperer to me, so appreciate her always. I move that we withdraw the following from EPA review. A, the Section 185 fee program rule provisions contained in subsections 101.118A, 2, and 101.118B adopted by the Commission on May 22nd, 2013, and submitted to EPA as a SIP revision on November 27th, 2018. B, the El Paso County Emissions Inventory SIP revision adopted by the Commission on November 16th, 2022, and submitted to EPA on December 8th, 2022. C, the attainment demonstration, reasonably available control measures analysis, and motor vehicle emissions budget elements contained in the DFW attainment demonstration SIP revision for the 2008 8-hour ozone standard non-attainment area adopted by the Commission on June 3rd, 2015, and submitted to EPA on July 10th, 2015. D, the attainment demonstration, reasonable available control measures analysis, and motor vehicle emissions budget elements contained in the DFW 2008 8-hour ozone standard, non-attainment area attainment demonstration SIP revision for the 2017 attainment year adopted by the Commission on July 6, 2016, and submitted to the EPA on August 5, 2016. E, the attainment demonstration, reasonably available control measures analysis, and motor vehicle emissions budget elements contained in the HGB attainment demonstration SIP revision for the 2008 8-hour ozone standard non-attainment area adopted by the Commission on December 15, 2016, and submitted to the EPA on December 29, 2016. The attainment demonstration, reasonably available control measures analysis, and motor vehicle emissions budget elements contained in the HGB serious classification attainment demonstration SIP revision for the 2008 8-hour ozone NACS adopted by the Commission on March 4th, 2020, and submitted to the EPA on May 13th, 2020. And finally, G, the attainment demonstration, reasonably available control measures analysis, and motor vehicle emissions budget elements contained in the DFW serious classification attainment demonstration SIP revision for the 2008 8-hour ozone NACS adopted by the Commission on March 4th, 2020, and submitted to the EPA on May 13th, 2020.
I second the motion.
All those in favor say aye.
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 Thank you. The motion passes. We will go to item 14. Give y'all a second.
Item 14 is the consideration for adoption of 2 total maximum daily loads for indicator bacteria in the Halls Bayou Tidal and Willow Bayou watersheds of the Bay and Estuaries Basin. And the executive director's staff is here to present this item.
Good morning.
Hi. Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today are Wyatt Eason with the Total Maximum Daily Load Program and Aubrey Pawelka with the Environmental Law Division. Today, the Executive Director is requesting final adoption of 2 total maximum daily loads for indicator bacteria in the Halls Bayou Tidal and Willow Bayou watersheds. The TMDLs cover 2 assessment units and 2 water bodies within Brazoria and Galveston counties. A stakeholder group was formed with balanced representation of all interested parties who were tasked with providing input on the TMDL document. The active public participation effort and balanced stakeholder group was coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document and improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Nicole. Any questions? All right. Do we have anyone signed in on this?
No one is signed in on this item.
Garrett?
OPIC has reviewed this item, and we appreciate the lengthy stakeholder engagement process, which started in 2016 and led to creation of the Chocolate Bay Coordination Committee. We also note that a public meeting was held last January. A public comment was received from EPA, and staff has appropriately responded to that comment. OPIC supports adoption of these 2 TMDLs for indicator bacteria in the Halls Bayou Tidal and Willow Bayou watersheds found in Brazoria and Galveston counties.
Thanks, Garrett. As always, I'd like to thank staff for all the work that went into drafting and finalizing these TMDLs. I'd also very much like to thank the various community stakeholders for their input and participation in the process. It was a lengthy process, a lot of people involved. I'm ready to adopt the document. Colleagues?
I'll only add the work continues. The implementation plan is sure to follow. I look forward to seeing that and appreciate the stakeholders' ongoing efforts to engage there.
Absolutely. Thank you. Do I have a motion?
I move that we adopt the 2 total maximum daily loads for indicator bacteria in the Halls Bayou tidal and Willow Bayou watersheds as recommended by the executive director.
Do I have a second? Okay. All those in favor, say aye.
Aye.
Aye. We'll go to the enforcement docket.
Okay, that takes us to enforcement items. We had several that were remanded at the ED's request, so the commission will be hearing items 15 through 18, 20 through 21, and 23 through 30. I have 31. Did we remand 32? Is that one of through 32? Okay, we remanded 30. Sorry. Let's call it 15 through 32, but acknowledge that 19, 22, and 31 have been remanded.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 15 through 18, 20, 21, 23 through 30, and 32. The total assessed administrative penalties are $325,127, with $69,622 deferred, $147,760 applied for supplemental environmental projects, and $107,745 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Melissa. Any questions for ED? All right. Do we have anyone signed in on these items?
So on item 18, we have an individual signed in who are available to answer questions. And on item 24, we have Michael Smith signed in.
Mr. Smith, would you like to come and make your comment, please?
I'm here because I got this letter in the mail that
Hey, sir, I'm sorry. Would you state your name and which
my
item
name is
you're
Michael
commenting
Smith.
on?
I'm with Mike's Tire Shop, Highway 277 in Bronx, Texas. I am here because I got this letter in the mail. They're fining me $5,007 for something I'm grandfathered in on as far as my tanks being in the ground. I called Austin when I first heard of it a couple of years ago, and Austin says that I was grandfathered in. So when I talked to my local TEQ, they said that I needed financial insurance. So I talked to Austin again, and Austin says that y'all just needed to have a meeting. Then y'all would let all the other divisions know, then I'd be good. And I ain't heard nothing from y'all until Friday when I got this letter. That's all I got.
All right. Which item is that on 24? 24. Do we have any questions for this gentleman?
No, thank you for coming up today. I'd love to hear from ED staff about that matter.
I would actually like to remand his item to the executive director and look into it a little bit more. Colleagues? It's good.
So I'm free?
You are free as a bird. So anyone else signed in for comment? Don't we have one more?
No one else has signed in to address the commission. So I think you can move on to OPIC.
Garrett?
OPIC has reviewed each of these enforcement items. We would have no objection to the remand of item 24, and except for remanded items 19, 22, and 31, we support adoption of all the orders presented by ED staff.
Thank you, Garrett. I'd like to thank staff for their work to bring these items before us today. I've reviewed the items that are before us and ready to move forward with the caveat that I would like to remand item 24 to the executive director for further analysis. I'm getting my motion.
Chairwoman, would it be appropriate to ask ED if they have any comments on 24 at this time, or?
Mary? Sure.
So I can just start from the enforcement division, and then I'll turn it over to Gitanjali for further discussion. So for the record, I'm Amy Sedemeyer with the enforcement division. Prior to referring this matter to the litigation division for resolution, we did communicate to the respondent on several occasions that they were not, in fact, grandfathered in. We did look into that claim and communicated that it was a valid order and tried to get to a settlement with them. And then I'll let Gitanjali pick up on their comms from that point on.
Thank you, Amy.
That's correct. This is a default order. The issue is service, but throughout the process in the enforcement division and the litigation division, we understood respondents' position, and we communicated that our position was that they either needed to provide financial assurance or to be exempt from those requirements to empty the tanks and do a site check. These tanks are empty, but the site check had not been done. And throughout the process, we made clear that they either, if they disagreed, they needed to file an answer. I do have a timeline that kind of goes through what our communications have been to respondent, and it's different than, it's clear that we made communication both in writing, phone calls, emails, as to the options and the fact that the agency did not, there was a disagreement about the position about being grandfathered and what the requirements were.
I thank you for those comments, and I understand. Can I? No. You looked at me sternly. Yes. I thank you for the comments. I would still like to remand 24 to look at the communications again to ensure that we fully communicated with the individual. The fact that he just received this letter on Friday and made his way up here, I just would like to look at that, the timeline again.
Okay.
And the communication. Thank you. Any questions?
No, sometimes I think, with citizens that, they're living their life and they've got other things, raising families and working and, community activities. And, sometimes they miss the stuff that's not always great, but it might be good to just try to set a meeting with them and have that conversation.
I appreciate those two comments, and I appreciate the staff's update on what their efforts and their perspective on this matter is. I appreciate how a remand does generate an extra step, extra level of conversation. I think it does improve the idea that our agency does work tirelessly to try to communicate and explain to the public that engage. Certainly where this is sitting on the default side of our docket, hopefully we could get it moved into an amicable and agreed order, but I appreciate staff's extra look on it, and I think it's worth taking that time. I regret that he received that latest communication in the timing and manner just before this meeting. So appreciate it, Chairwoman.
Yep,
Thanks.
thank you. And I very much appreciate your comments. And I agree, Katerina, that sometimes, our citizens just miss things, or they are trying to run businesses. And what we do is really complicated, y'all. So I just want to ensure that he is fully briefed, and we'll move on from there. And I have a motion. I'd like to adopt items 15 through 18, 20 through 20 to 21, 23, 25 through 30, and 32, remand 24 to the ED for further case analysis. And that's it.
I second that motion.
All those in favor say aye.
Aye.
Aye. Thank you. We very much appreciate what y'all do.
Yeah, thank you.
All right, I think we are moving on to item 33, the enforcement report.
Yep, that's correct. Item number 33 is consideration of the monthly enforcement report, and the executive director's staff is here to present the matter.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through May. There were 798 effective administrative orders issued, and of those, 77 contain supplemental environmental projects. These orders assessed a total of $10,506,511 with a payable amount of $6,604,590. $2,400,034,887 are to be paid towards supplemental environmental projects. 15,227 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,322 enforcement action referrals have been received. There are 3,168 pending administrative orders with 1,402 cases that are on the backlog. Of this number, a majority of these cases are proposed orders within the Enforcement Division that are awaiting settlement or other resolution, or orders which have been referred to the Litigation Division. As the date of this report, there were 407 orders pending mailout that are considered backlog based on current criteria. This number represents a decrease in our pending backlog of almost 50% since the beginning of the fiscal year. 133 cases are pending at the Attorney General's office for representation in district court, and 8 judgments have been issued. 1,532 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Amy. Any questions or comments? Is anyone signed in on this item?
No.
Garrett?
Public has no comment except to say that, as always, we appreciate staff's report.
Yes. Well, thank you. And we very much appreciate the report too. The numbers are staggering. The amount of work coming to this agency is extraordinary. I am very optimistic that the wonderful budget that was passed that will give us additional FTEs and additional funds will help with this backlog, but I do know staff are doing their absolute best. A 50% reduction since the fiscal year is excellent.
And I just want to make sure it's the pending. And that's representative of us moving cases more quickly.
Yep.
And so we're still working hard and trying to get through it, but making progress. So
Very good. Do we have a motion? Oh, no action needed. Thank you. Thank you, Amy. We will go to item 34, rule matter.
Item 34 is the consideration of the publication of and hearing on proposed amendments to 30 Texas Administrative Code Chapter 39 and 30 Texas Administrative Code Chapter 55, and corresponding revisions to the state implementation plan. And the executive director's staff is here to present this item.
Good morning, Amy.
Good morning. Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amy Browning with the Environmental Law Division. The proposed rulemaking would add new sections to and amend 30 Texas Administrative Code, Chapter 39, Public Notice, and 30 Texas Administrative Code, Chapter 55, Requests for Reconsideration and Contested Case Hearings, Public Comment, and make corresponding revisions to the state implementation plan. The proposed rulemaking would implement the required changes to TCEQ public participation rules provided in Senate Bill 1397, the Sunset Bill, from the 88th regular legislative session 2023. The proposed rulemaking proposes to extend the comment period and opportunity to request a contested case hearing for at least 36 hours for air quality permit applications with a consolidated notice following a public meeting, and amends notice requirements related to contested case hearings for air quality permit applications. It also clarifies the Commission's rules to improve the public participation process for permit applications. This includes adding new definitions and making general language and readability improvements. A hybrid in-person and virtual public hearing will be offered on this proposal on September 8th, 2025. A Spanish language interpreter will be available for the hearing. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 39, Public Notice, and Chapter 55, Request for Reconsideration and Contested Case Hearings, Public Comment. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Amy. Has anyone signed in on this item?
Yes, we have Catherine Guerra with Public Citizen.
I believe I saw her earlier. Catherine?
Hello, good morning, Commissioners. Catherine Guerra with Public Citizen. We are very much looking forward to the agency's implementation of these required changes to the TCEQ public participation rules provided in Senate Bill 1397, the Sunset Bill, which Public Citizen, together with other stakeholders, was extensively involved with. These were hard-won changes, although on the more modest side of the improvements requested or that we believe are needed, the Public Citizen remains fully committed to seeing them each fully implemented. The sunset recommendations are the minimum, but there's nothing limiting the agency from doing more to gain the public's trust and its ability to make public participation more accessible to all Texans. Public participation is not simply a box to be checked. There has to be a more holistic shift in the agency's mindset about how it ensures the public is able to effectively engage in agency decisions. Something as simple as displaying an informational slide for the entire duration of a recent public hearing with English on one side with correct agency deadline date and the Spanish translation directly next to it with an incorrect date, although written numbers need no translation from English to Spanish. There is a consistent disconnect between the agency and the public, and we hope that these new rules will improve the public's experience and their perception of the agency. These recommendations obviously would not have been necessary if the agency had the initiative or willingness to implement them itself. And if this rulemaking is not being informed by the agency's Title VI efforts, it must. Thank you very much.
Thank you, Catherine. I'm sure you will have some very thorough comments for us once we post these. Garrett.
Hi, thank you, Chairwoman. That'll actually be me this morning. So good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. OPIC has participated in this rulemaking proposal, and we agree that the Executive Director should proceed forward with this for publication and the taking of public comment. OPIC understands that this rulemaking is necessary to implement changes required by TCEQ's Sunset Bill. We note that a public involvement plan is required, and this process will feature alternative language requirements as well. We've observed a robust level of public participation in this matter so far, and we note that a substantial amount of comments have already been received. We appreciate the Executive Director's efforts to involve the public by conducting multiple stakeholder meetings. And we plan to attend the September 8th public hearing and monitor public comments that the Commission receives as this process unfolds. Finally, While this rulemaking is still in its early stages, we would like to express our support for expanding the opportunity to provide public comment and request a contested case hearing for certain types of air applications. And as always, we are supportive of efforts to clarify and simplify the chapters, which we believe will work to encourage greater public understanding and more effective participation. Thank you, and I'm available for any questions.
Thank you, Sheldon. Any questions for OPIC? Well, this rulemaking is an important step towards implementing our sunset bill, which we are very happy to do. And I believe it will greatly enhance transparency and encourage public participation and engagement. I want to state my gratitude to everyone on the rule team who put countless hours into working on this proposal, especially to the rule team leader, Amy Browning. I heard that you are now queen of herding cats and playing arbitrator on definitions. So bravo, very, very proud of you. For all the work that's gone into developing this rule package, I understand it was a coordinated effort between many program areas, and I think staff has done a really, really great job. I'm looking forward to hearing what the public has to say, and I'm sure they will be very vocal on the proposed changes to these rules, and I would be in favor of moving forward with the publication of this package. Colleagues?
Thank you, Chairwoman. I think I share all your thoughts on it and look forward to the full public comment record on this particular rulemaking. I just want to respond in particular to Ms. Guerra's comment from the public citizen. I appreciate them
Please do.
engaging and indicating the importance of this matter, but on the one hand, you recognize how this was a hard fought and important issue to elevate to the sunset process review of what our agency is under a constant pressure cooker to be responsive minute by minute to those applicants inside of the fence line, as well as members of the public outside of the fence line who are as urgently wanting a response from us on health-related matters. But then you say that we could have done that change if we wanted to do it. And I think that that's where it just upsets me a little bit, to suggest unfairly that our agency simply could switch a switch and make these changes when we're under intense pressures. And I think responding rightfully to trying to manage the limited resources and limited allocated government responsibilities that Texas has decided up until now to intrude into the public-private space. And so I really appreciate your focus. I appreciate your cheerleading for protecting the environment in our state. And I think this is an important change because it came at the very end of the rulemaking but permit action process, where our agency will conclude a public meeting and give the public an opportunity to comment right up until the end of that moment, to give a written or oral comment. And it feels wrong from the public's perspective to have the door closed there, where perhaps they go home and sleep on it. And they think, oh, I wish I'd said something else, or I wish I'd highlighted this other aspect that I'm concerned about. So giving them an extra stretch of time past the close of that public comment window, that meeting, I think is a fair point to move the needle. But the legislature recognizes and realizes that we can't do that without that public support and backstop from the legislature. The sunset process highlighted that and pushed us towards that change. And I just appreciate the engagement from all directions and all sides, but I do want to remind the public how much our staff has very real work balance or workload balancing considerations in terms of prioritizing the various intense needs of the state and the day-to-day changing work posture. I remember personally from working in the agency program staff side where we moved from, and it's a perverse incentive, I'll acknowledge, but we moved from having an open comment period that we thought had not had a comment provided because that meant a very simple workload off-ramp for the staff to, oh wait, no, there was a comment from someone who maybe is an affected party. It was in a rules inbox somewhere in a different point of the agency. We would have had every legal backstop to say, sorry, that's an invalid comment. We honored it, brought it into the permitting process, and dramatically changed the path. So I just want to acknowledge how much these permitting decisions, actions, and timing are very, very important, and this is an important change. I'm glad that our agency is doing it, but I just want to contextualize where we're always playing tug of war, and I appreciate the staff's work on this piece, and I think many of us in Texas see that work. So thank you.
Absolutely. We're never going to make every stakeholder happy, but we sure as hell tried with this. So I really appreciate it. I'm wearing yellow today, so I'm trying to be nice. So I appreciate you taking that on. For me, I'm protecting my peace this morning. Katarina.
I appreciate that too. I could not, I think, disagree more with the comments that we received. But I'm happy to see our agency continues to implement the recommendations that the Sunset Commission suggested to help our agency's transparency and public participation. It's very important. Our agency, I think, continuously works to improve transparency and allow for public participation. And these proposed rule changes, I think, for the most part, will help in that effort. I do agree with many of the recommended changes made to chapters 39 and 55 as proposed by the ED, and I support fully the implementation of SB 1397. However, I do have some concern with portions of the rule going beyond what the sunset recommendations require. So I'm interested to see what public comments we get, but I do support moving forward.
Excellent. Well, I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code Chapters 39 and 55 and corresponding revisions to the state implementation plan as recommended by the executive director.
Second the motion.
All those in favor say aye.
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 And again, Amy, thank you. Let's put them out and see what the public says. All right, we're moving to item 35.
Yes, items 35 through 38 are for closed session. The commission will meet in closed session in room 242 of the Texas Workforce Commission. Do you want to say 11:45? At 11:45, as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 through 074, to take up and consider matters pursuant to item numbers 35 through 38 as posted and noticed.
This meeting stands in recess. The time is 11:31 a.m. Thank you.
Texas Workforce Commission for closed session from 11:45 until 11:57 a.m. on item number 35 as posted in notice pursuant to Texas Government Code, Section 551074. No action was taken. The agenda stands adjourned and the time is 12:01.